rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning.
Good morning.
I am Judge Faruya, and to my right is Judge Morse. To my left is Judge Weinsweig. And we are here for oral argument today in our case number CV24-0116, Thomas v. Peters. As you may know, we record and live stream these proceedings, so please give your name and the name of your client before you begin. You have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require you to keep track of your own time, and the clock on the podium will reflect that, but it also includes all remaining minutes. So if you'd like to reserve anything for rebuttal, that will be up to you. You're free to do so, but your time on that clock will include that rebuttal time, so please be aware of that. Please keep in mind that we have read the briefing, we have studied the record, and discussed this case in conference, and with that, you may proceed, counsel.
Good morning. Joseph Brophy on behalf of the appellant Joshua Peters, and may it please the court. The threshold and central issues in this case are of jurisdiction and interpretation of the rules of civil procedure, specifically the meaning of impracticable under Rule 4.1 K1.
Was the impracticability argument raised anywhere outside of the reply to the motion to set aside?
The fact that there was a single attempt at service was raised in the motion to set aside.
But that wasn't my question. My question is, did the word impracticability appear anywhere outside of the reply to the motion? Which that reply was filed after the judgment was entered. Am I correct in that?
Yes, the Superior Court entered the judgment, I would say, prematurely before the time to file the reply had run. And I believe probably what happened there is that sometimes it takes a day or two, or sometimes even 3, for a filing to appear on the court's docket. And I suspect that what happened was when the court entered the default judgment, it may not have had not received all of the filings that had taken place that date. I don't remember the exact timing of everything.
I think we're getting a bit off track. The question was, did the word impracticability appear anything before the reply?
I don't know the answer to that. I do know that the issue of the single attempt at service was raised in the motion. I don't know if it was raised, if the word impracticability was used in the motion to set aside. The standard of review for both of those issues, interpretation of the rules of civil procedure and jurisdiction, is de novo. This is an appeal from a default judgment that arose.
Let's assume that you didn't say impracticability or frame any argument. Why should we grant you relief now? I mean, we have a lot of cases that say we don't consider issues that weren't raised before the Superior Court, and raising something for the first time in a reply is insufficient to raise it for the Superior Court. So why should we overlook that precedent?
Well, it was raised before the Superior Court. It was in the reply brief, and there was no objection raised regarding that issue.
And
the Superior
I asked
Court.
you, there's a bunch of cases that say something raised in reply is insufficient. You can't raise it that way. Why should we overlook those and now let you kind of raise it for the first time on appeal?
Well, again, I would respectfully disagree that it's being raised for the first time on appeal. It was raised to the Superior Court. There was a hearing requested. The Superior Court decided not to do that, but it is in the record. There is extensive briefing on it. The Superior Court and the appellee didn't really challenge.
Because you raised it in a reply. They didn't get to file a response to a reply.
Well, if they felt that there was a problem with that, then they could have asked to file a surreply, And I would also note.
Or they
that-
could just say, you didn't raise it, and so we don't have to address it.
Well, I would also note that in the answering brief, there's really no challenge to this either. So even when the opportunity was afforded to the appellee to say, here's why it was impracticable, there's simply no response to that. And ultimately, as you well know, the preference here in the policy is that matters should be resolved on the merits, and that when you're dealing with matters of service of process, jurisdictional service of process, those rules are strictly construed.
You had actual notice, though, right?
Yes.
And you actually sought 2 extensions, you could have filed a response.
Correct, but that gets to the issue of.
So how is this, other than just saying, we're going to throw away deadlines and make them never apply, how is this a situation in which we should really err on the side of seeing something resolved on the merits?
In Smith versus Smith, 117, errors 249, where jurisdictional notice is required to be given in a certain manner, any means other than what's prescribed is ineffective. Same case, knowledge by a defendant as to a pending lawsuit will not operate to cure a defect in service.
Okay, so let's run with that. Is the argument that they did not post, because the order allows service by posting, right?
Right.
So the argument isn't that they didn't post, they did post, correct?
There's 2 arguments on that, and it's not the posting. It's that the court's order and Rule 4.1K1 require 2 things, posting and mailing.
I'm sorry, my question was, the argument is not that they did not post, correct?
No, that's not correct. That's not the argument.
Okay. And your argument is also not that they never mailed, correct?
Well, that gets to sort of the second issue, which is what's required under Rule 55 if you're going to default someone, which is you have to file an affidavit testifying that the service was mailed. And you're not going to find that anywhere in the record. And so this sort of gets to.
There's nothing in the record that says that they mailed it.
Nothing under oath. What you have is the application for default was filed on November 14th. The first time any reference to a mailing of the complaint appears is, I believe, in the response to motion to set aside, which is sometime in mid-December. And so this is where you get into this question of, okay, if you file, and I believe what it is, it's a certificate from the post office. If you file that 2 months after your application for default, and it's not under oath, does it retroactively bestow the Superior Court with jurisdiction back on November 14th when the application for default was filed without an affidavit saying that the summons and complaint was mailed in accordance with the rule and with the Superior Court's order?
Counsel, it seems to me, okay, so your whole argument here is about jurisdiction. This is a jurisdictional argument. And if I understand you correctly, your argument is there was no jurisdiction to do this because you didn't adequately serve. Is that the substance of what you're saying?
That, and that the default itself, so put service aside, that the application for default was also defective because it didn't come with the required affidavit of mailing that is required under Rule 52A2F, I believe.
What's the purpose of service?
The purpose of service is to give notice, but as I just read, there's multiple precedents from the appellate courts of this state that says when you're dealing with jurisdictional notice, actual notice doesn't suffice. The rule has to be followed.
Okay.
And I don't think that there's any dispute in this case that multiple rules were not followed. Rule 4.1K1 wasn't followed, and Rule 52A2F was not followed, and that rule incorporates Rule 4. I think it's Rule 4G that says that proof of mailing has to be done by affidavit.
Okay, so let's go to 4G. I'm looking at Rule 4, subsection G6. And it says, failure to make proof of service does not affect the validity of service.
Right. There's two issues getting mixed up here. On the affidavit, that is not an issue of service. That is an issue of whether or not the application for default is valid. So the issue is not service. The issue is when you do an application for default, you have to submit an affidavit saying that service was accomplished in the manner that was required. So that is a separate issue from whether or not service was properly effected under Rule 4.1. Does that answer your question?
Did you raise those issues below when the application default was filed?
No, at the time the application for default was filed on November 14th, that nobody had appeared.
Okay. But you did subsequently appear, and did you file any opposition to the application for default saying that it was invalid for those reasons?
Well, yes, that was brought up in the motion to set aside.
So that's the first time it appears, is the motion to set aside.
Yes.
Okay. So, and there was a notice of appearance before that. Am I correct in that? I think I am.
That is correct, yeah.
Okay.
I believe on November 27th.
Right. So that would be within the time frame of the first extension that was given because of the Thanksgiving holiday. So there was a request for, if I'm recalling correctly, a 10-day extension because the impending Thanksgiving holiday. So that notice of appearance was within that time frame, was it not?
Correct.
Okay. Did your client actually get the complaint?
At some point, yes. There was an issue where he was not, that is where he lives, but he was not at the house. And so he got it, I believe, fairly late, well into November.
And his counsel got the complaint because there was a notice of appearance, right?
Correct.
Okay. So there's a notice of appearance. What does that filing of the notice of appearance do? Because we're talking about personal jurisdiction.
Sure.
So, and it wasn't it was just when I looked at it, correct me if I'm wrong, it was just a notice of appearance. It wasn't a motion to dismiss for lack of personal jurisdiction.
And on the
You
issue,
didn't reserve any, or counsel didn't reserve the right to contest personal jurisdiction in the notice of appearance.
well, I mean.
I've seen them before where they say, we're only appearing for this limited purpose of contesting personal jurisdiction.
Right, but what the case law of this state says is that to waive an argument on, particularly before you even filed a responsive pleading, to waive that argument, you have to both file a general appearance and argue the merits of the case, which never happened in this case.
What's your best case for that? Because I haven't looked at them recently, but I thought there were cases that say if you don't reserve jurisdiction, personal jurisdiction arguments, you've waived them.
That wasn't brief, so I don't have one off the top of my head, but it's basic. If you look for general appearance and merits, basically, in waiver, that will come up, that it says to waive that argument.
Well, you just said case law says, so I'm just asking for what case you're saying.
I don't have that off the top of my head.
Okay. Fair enough.
I'm sorry. Was there another question?
I may have interrupted. I'm sorry.
Yeah,
My question is, I'm having this difficulty about how that you have a voluntary appearance and with no reservation of the issue of personal jurisdiction, nothing like a motion to dismiss for lack of personal jurisdiction or anything like that. You just have a notice of appearance. And I understood your response is case law says that we don't waive that by filing a notice of appearance.
correct.
That's your response. Okay, so that was the question and that was the response.
That gets waived where somebody appears, they argue, and you start arguing on, and there's some type of argument on the merits. What you're not going to find is a case like this where we're here on a default judgment. So by definition, there was no argument on the merits. And so I mean, it's not like there was an answer filed without raising it or anything like that. There's an appearance, there is an order by the court that says, I believe the answer is due on December 1st. That order is entered on December 4th. And so what you really have then is, in the first instance, you have a complaint that was not properly served because impracticability wasn't established. At the time that the application for default is filed on November 14th, the Superior Court doesn't have jurisdiction to start any type of clock running. So there's a notice of appearance on 27th in order to file an answer by the 1st, and so the earliest that any clock can start running is on that November 27th date when the notice of appearance is filed. Everything before that, unless there's something in the record that can justify a finding of impracticability, is void. Superior Court didn't have jurisdiction.
Why do we not, because we have no transcript, right? And so why do we not assume that the judge implicitly found it was impracticable?
Well,
I mean, we do have a motion for alternative service, and we do have testimony that said that, you know, he attempted service, and so, I mean, you may disagree with that evidence, and I may even agree with you that that's thin soup, but what is the standard on review for that particular finding?
it's jurisdictional, so it's de novo. It's absolutely de novo, because it's a jurisdictional issue.
Isn't it factual, though?
I mean, what we're talking about here really is, the question is, was it impracticable? And I agree with you, if there's nothing there that says that it's impracticable, right, then you have a substantial evidence issue, right? And then that is reviewed de novo, and then we say, okay, well, now we're talking about that. But we have here, the process server gives evidence that he attempted to serve it, that they were evading service.
That who was evading?
Lying to it.
That who was evading service?
Well,
That's the thing.
Well,
and what I would refer you to, Judge, are the two prior decisions of this court, both times that have said a single attempt at service is not sufficient to establish impracticability. And so what the court would have to do is distinguish both the Schrader and the Norman cases, which are discussed at length in the briefing, and quite frankly aren't challenged.
I don't recall those cases, correct me if I'm wrong, but I don't recall those cases as saying that when somebody's there and lies to the process server that someone's, like, they don't live here, that was the facts of those particular cases.
There is no testimony in the record that, not only is the testimony not that they lied to him, the testimony from the process server is, I have no proof they're lying to me. It's exactly what he said. And so I don't know how you look at that, Judge. I mean, even if you were to decide this on an abuse of discretion standard, the Superior Court doesn't have the discretion to take the evidence and make it the opposite of what it is. And I would encourage you to read that affidavit of service.
Is that really the opposite of what it is?
I have no proof they're lying to me. If the position that you're going to take is he gets there and they lie to him, but his affidavit says I have no proof they're lying to me, I don't know that one follows from the other.
Okay. Let me shift gears just for a second, and
Yes.
let's kind of go back to this one issue. What is the purpose of a notice of appearance? You had said earlier that wasn't an answer, right? And that's why we didn't waive anything by our appearance. But if that's the case, then what is the purpose of a notice?
Basically, you're letting the court know that you're there and you're submitting to the jurisdiction of the court at that point.
Okay.
And there would be no dispute that as of November 27th, the Superior Court has jurisdiction. The argument here, though, is that everything that happened prior to that, there is no jurisdiction, and specifically the November 14th application for default. That if you don't have valid service in the first instance, because there's not a showing of impracticability, then the Superior Court, under the rules of civil procedure, can't start any clock running because of an application for default, which I would remind the court did not have the appropriate affidavit, which is required by Rule 55A2. And we did cite a number of cases in the briefing from other jurisdictions where in the federal courts they've said, look, if the rule on default requires you to file a certain type of proof of service and you don't file it, then the default is invalid. I've got a minute and 20 seconds. Unless there's any questions, I'd like to reserve the rest of my time for rebuttal. Thank you.
Mr. Noel. Or is it Noel?
Good morning. Richard Noel, appearing for Thomas Restoration, the plaintiff appellee. To the issue of impracticability, my response brief may have glossed over some of the things admittedly, because I think I was kind of struggling with what the actual arguments were being made here, because from our perspective, it was very clear that this is simply, we just failed to file the proof of mailing, despite the fact that we had mailed. But to the issue of impracticability, we'll start there. The Schrader case, Barlage, Ruffino, those cases, as I believe the court's kind of alluded to, the court has always examined whether or not evasion is at the heart of that. There's always a question of, in any one of those cases, it is true that defendants were never contacted. A process server didn't go out and was told lies by someone, be it the defendants or someone who was in defendant's home, whatever the case is. None of those cases have anything to do with what happened in this case, which
What's
is...
your response to your colleague's suggestion that his affidavit says can't prove they were lying?
It also says, I feel that they're lying. And so we have to rely on an officer of the court who we use all the time to make those kinds of judgments. And when you have someone, as the affidavit points out, driving through a coded gate and then stopping and said, I don't know that person, and immediately hopped in the car and drove off. You have another individual, a blonde person, who, by the way, matches the description of a defendant, answering the door and saying, this person doesn't live here. Well, do you live here? No, I don't live here. Well, how long have you lived here? I'm not, that's none of your business.
So it's more like, instead of saying, I can't prove it, it's like, well, I can't prove it beyond a reasonable doubt, but here are the 5 factors that led me to conclude.
Exactly. We do rely on our process servers to make a judgment call. And
the court's entitled to look at that and say, I think there's enough there to show lying, which would support impracticability.
Well, yes, I believe that, coupled with the fact that, in our opinion, the property at issue here, where the service was made, was dumped into an LLC as communications broke down pre-litigation. The timing of that was suspect to us. It was an out-of-state LLC. We looked at the quitclaim deed that was gifted to an LLC. We found that the defendant shared a P.O. box in Wyoming with this same Wyoming LLC. We put that together. We took the affidavit from our process server, the facts from that, and then we took a social media post that matched the front door of the house with a Zillow listing of the house, and gave that to the court and said, please give us alternative service via posting and mailing. We don't feel, based on all this, that it's impractical to continue doing.
There's hijinks going on, and you guys were trying to protect yourselves.
Essentially, yes. We wanted to make sure we covered all our bases, and we had to show the court, hey, we can't prove, based on the actions of the defendant, that he still owns the property, which makes it a bit difficult sometimes when you're trying to get alternative service, or to prove to the court that that was the case. We did the best we could. We feel that the trial court absolutely had the ability to find impracticability, even if they didn't state it as much. They did grant the motion for alt service, and we did what we needed to do. Now, we did admittedly...
Get to impracticability? I mean, I'm still hung up on the fact that it wasn't raised in a way that I can discern until the reply below.
I would certainly agree that it was not raised, and I was admittedly blindsided by it, and I didn't really have the opportunity to address impracticability, because it seemed to us also, and it still seems, very clear-cut that there are serious attempts by someone to evade service and litigation in this case as a whole, and that was what was presented to the court. So based on that, we felt that absolutely the trial court was able to look at those facts and say, yeah, we agree with you. Don't go back. You've encountered 2 hostile people who have threatened to call the police. Go ahead and do what you got to do. Post and mail. I posted. I mailed. Yes, I admittedly did not realize until the filing of the motion to set aside that I had forgot to file the notice of mailing. And the reason for that is simply that I was, at the time, my process server was not doing the mailings. They were just doing the postings, and I was doing the mailings mostly to save my clients some money.
Why are we going to hold him or his client accountable for their failures, but not hold you accountable for your failures?
Well, simply put, again, under 4G6, failing to file does not negate service. Service was made at that time. And again,
Yeah, but
when...
there's also requirements for an application of default, and you
Yes.
at least failed one of those. So why wouldn't we just vacate it and send it back, let the trial court?
Well, I would say, Your Honor, that default in general is a unique situation. And in this case, not all courts have an application for default process that Arizona has. It is a bit unique. And I think that, the overall
That's fine, but
purpose...
we are in Arizona, so you comply with Arizona rules.
Yes, absolutely. But I think the overall purpose
I wouldn't
was...
spend much time talking about what other states require. Just tell me why we don't hold you accountable for your failures under 4G6.
Well, again, Your Honor, I think the issue was never raised. When counsel reached out and said, hey, we've got the application for default. Based on that, can we get an extension, which I granted. Then I granted another extension. Then I granted a third that I just waited another week before I filed. At no point was that issue ever raised of, hey, we feel like they're not really in default. At that point, I would have either corrected and said, well, now I'm going to refile, or I would have said, okay, no worries, let's just get this case going. I made it very clear at that time that this case needs to move forward. So when it wasn't raised, honestly, it was, I didn't realize at the time that that was the case. However, again, the purpose of default is to allow a person to file a responsive pleading and to avoid a judgment. That is what the case law suggests, and that is the ultimate purpose, and that is the ultimate goal that was achieved. That goal was achieved here. So yes, it is true that I forgot to put in the affidavit that the application or that the stuff was mailed.
What case would you best cite to say that we can overlook that omission?
Give me a second, Your Honor. I would say... I would say Schooley v. Pena, 253 Arizona 185. If you read that case as a whole, ultimately paraphrasing, again, it goes back to the purpose is simply to make sure that somebody has a final opportunity to answer. They had multiple opportunities to answer. They had almost a month to cure default and never did. They never raised the issue that default was improper. I didn't realize it was improper. And then now after the fact, after judgment was entered, they said, hey, let's unwind default. We didn't raise it for over a month.
They
but we're
certainly
gonna do
have
it
plenty
now.
of time to, even if they're not going to file a responsive pleading, they could have filed something in opposition to your application for default.
Yes, I agree. And again, usually when there's a situation when an opposing counsel reaches out and says, we think there's an issue with default, I would immediately address that with them. But that was not the case.
But that's all extra record communication.
Absolutely, absolutely, I
They
agree.
could have filed something, a motion to strike or a motion. in
Yeah,
opposition to
a motion to dismiss for, hey, you didn't make service correctly because we don't see where you mailed. Those issues were never raised. So service was done. I don't think that can really be disputed based on the facts. I think it is impractical to do so based on what the trial court found. I think that even if the trial court looked at the affidavit in the application for default, they did so in the motion when I filed my proof. They were able to look at that all as a whole and determine whether or not it was appropriate to set aside default. They found that it was not appropriate to set aside default, and I don't think that that should be disturbed. So, sorry, I hope that answers your question. Okay.
Sort of.
Okay, sort of, okay. And then ultimately, Your Honors,
What did we make of that? Because counsel's argument is that there was no jurisdiction to run a time limit, right? So we're really back to this point about there being no jurisdiction.
I would argue that it's a question of facts surrounding jurisdiction. And the trial court looked at all of the facts and had privy all of the facts when determining whether or not to set aside default. So based on this is a factual, it really is a question of whether or not the trial court erred. Whether they clearly erred in deciding that service had been made, that the application for default was proper, and that ultimately you had a first, second, and third bite at the apple to file a responsive pleading, and then just failed to do so.
Just to clarify, it's not that the document wasn't mailed, right?
Correct. Correct. And I provided that proof to the trial court in my response, because that was the first time I realized I hadn't filed the proof of mailing, admittedly. So there's no refuting that.
Okay.
So,
But it was in fact mailed.
yes, absolutely. And again, the trial court stated in their January 18th minute entry, I think that really sums up our position. They hit the nail on the head with it, which is you didn't say service was improper. You didn't say you didn't get the documents. Attempting to shift or to make an argument that, hey, the trial court erred in requiring us to make a showing, no. If you're going to say service wasn't made, you should have raised it. You don't get to say you didn't get the mailings, or I apologize, let me back up, that it's clear the mailings were done. We have proof that you got the mailings. So why didn't you, I think the trial court questioned in that minute entry, ultimately saying, well, you didn't raise the issue, saying you never got the mailings, so it seems that service was effective. And you're here, we're all here. So, and then you didn't answer. You didn't answer after one extension, after two extensions, and after another week before I filed my motion for default. So that is our position. I think ultimately, and to the final issue that I think was kind of touched on in the opening brief of whether or not I was obligated to, although it wasn't hinted at here, I just want to touch on it because we do have a position on it, whether or not counsel is obligated to retroactively send an application for default when counsel comes on the scene. Because on the 14th when we filed, they reached out on the 17th via email to us and said, hey, we see based on the deadline application for default, deadline is this, can we get an extension? At that point, there's no case law and there's nothing in the statute that says that I'm obligated to retroactively then provide court documents to opposing counsel and say, by the way, you know about default, right? They clearly already knew about it. So while it was raised in the opening brief, I felt it necessary to respond to that. So that is our position. Any further questions? Are we good? Okay.
Thank you, counsel.
Thank you.
Mr. Brophy?
Very quickly, I would just urge the court to look at the affidavit of service when you have comments up here being made that they were lying, they matched the description. None of that is in the affidavit of service. There's no suggestion that the process server knew who the residents of the house looked like and concluded that they were the people that he encountered at noon on a Monday. To get to a point that Judge Morris was making, I would just point out on page 30 of our opening brief on this issue of actual notice, the restatement of judgment section 3 comment D goes over this and says, actual notice very often will suffice except in the case of default judgments. Here again, there's a rational basis for treating an irregularity in notice giving as significant, even though the actual notice has been conferred. To do so is to apply a rule of parity among the parties concerning formal defects in procedure. And what's being asked here is only apply the rules to one side. Forgive me on Rule 55A in my affidavit, forgive me on impracticability and all these other things, but apply the rules strictly to the appellant. And perfect timing, I'm out of time, unless there are any questions. Okay, thank you.
Thank you. Thank you for your arguments, counsel. We will take this matter under advisement and issue our decision in due course. And this court stands in recess.